Good morning, everybody. My name's Larry Jacobs. This is Pre-K-12 Education Talk Radio, and it is Friday, the 10th of November, 2023. And I just want to remind everybody that tomorrow, is November 11th, is Veterans Day. So please say thank you to a vet. Our show today, on this Friday, the 10th of November, is with my good friend and our good friend, Dr. Howie Knopf. Dr. Howie Knopf is the president, as you all probably know, of Project Achieve. He's a very, very renowned school psychologist. He consults continuously with school districts across the country and internationally. He's based now in Fort Myers, Florida, where he is today. And we're going to be talking about the 7 suggestions to help districts avoid special education hearings. That's one of the things where Howie's expertise really shines. We're going to have a wonderful conversation. Of course, we're always concerned and happy to do a show about special education, which is so important, falls so fully under that umbrella of equity. It's just so darn important. And we're going to hear from Howie and all that stuff. And without further ado, here's Howie. Hi, Howie.
Well, good morning, Larry. How are you?
Good morning, buddy. I'm fine. Okay. Hey, Howie, I want to get into the show here. 7 suggestions. This is important because it has a lot to do with dollars. Dollars are tight out there. 7 suggestions to help districts avoid special education hearings. Okay. And I just talk about your experience in that. And I know you have a lot of it. And I also want to know, and you wrote this to me, why you think that the special ed cases are going to really increase over the next few years. Howie, you're on. Do it. Project Achieve, right. By the way, everybody. Project Achieve info. ProjectAchieve.info is the way you get in touch with Howie. Good.
All right. So let's do the front end of the discussion, which is really my experience. I mean, I do a lot of consulting around the country. Obviously, I used to be a university professor for over 20 years. I worked at the State Department of Education in Arkansas for 13 years, but I've always done some litigation. I've been an expert witness in court cases starting actually in 1993. So right now I'm working on a case actually of a 19-year-old student who was assaulted in school. This is on the East Coast. We just finished a case of a kindergartner student, an African-American kindergarten student who was bullied and harassed, and the parents actually had to move away from the school district. But even back in the 1990s, I was on 4 federal court cases in Montgomery, Alabama, representing African-American kids who actually were kids with special needs. Mm-hmm. And we basically went to federal court, and one of the cases involved corporal punishment, where they were not providing appropriate interventions. Their, quote, intervention for the student to control him was corporal punishment. So, I guess I'll say, unfortunately, I find myself helping school districts and parents in due process cases, but all the way up to many times in testimony in federal court. So that's the front end. The back end.
You and former President Trump in federal court. Congratulations. There you go.
Well, I think I'll avoid that connection, so we'll just move on. So why do I think
he's an expert witness? He's not on the stand. Go ahead. Yeah.
That's right. Why do I think litigation is going to continue and actually expand? And I think the primary reason is right now is because of the pandemic. What we had during a 1.5-year period of time was we had students who were sheltered at home. We have right now 14% of the country are students who are identified as disabled, and they are on IEPs. And so we had districts trying to deliver direct special education and related services to students in a virtual world. And that was incredibly challenging. And the schools were not prepared for it, let's just be honest. I mean, they did the best that they could, but they fell short. And to kind of add fuel to the fire in the middle of the pandemic, and I think rightly so, the U.S. Department of Education's Office of Special Ed Programs sent out a guidance paper, a white paper, and said, look, folks, it doesn't matter where these students are, you've got to provide the services that are written into their IEPs.
Wow.
So a critical point here is that, again, we fell short, but the pandemic has no statute of limitations relative to special education. And so what's going to happen in the next 10 or 11, 12 years is we're potentially going to have students who are now in high school who did not receive the special ed services that they deserved and were on their IEPs when they were in kindergarten, first and second grade during the pandemic. And that's going to become a pivot point to having all this litigation and potentially school districts having to provide compensatory services, which is not a bad thing, but the bad thing is litigation. So let me make a couple of points on litigation.
Go ahead.
School systems understand, and they need to understand if they don't, that when you're in a court of law, you've left the kingdom of education behind, okay? Because when you're in a court of law, if you're in even a due process case, where it's being arbitrated by somebody usually from the Department of Education, the State Department of Education, but if you're in state and federal court, the rules are now court-driven. You're testifying. You are, if you will, arguing against the law, against regulations. It's not about education anymore. And so sometimes what happens is that school districts lose cases, or sometimes parents lose cases, not because services weren't delivered, but because the appropriate services weren't delivered. All right, and here's my last point, then I'll throw it back to you.
Yeah, go ahead.
When you're in a court of law or where you're in any litigious kind of situation, you've got to understand that at this point, it's about winning and losing. But we've got to be careful about thinking in that mentality as educators, or me as a psychologist. It's not about winning and losing, okay? Because what happens sometimes is that districts may win a case and they may get the short-term win, but they may lose the long-term relationship with that student and that parent.
Of course.
And so even though you're in a court of law, you're bound by the law and the regulations. Once the court decision is made, it's still about relationships and service delivery. And sometimes what happens is we have educators and administrators, and especially school board lawyers, and right now they want to win. But again, they may get the short-term win, but lose the long-term war.
Yeah, and you know, it's an interesting thing. I hope not. I'm going to make this blanket statement. No school district really wants to harm a child. Okay, they really want to do what's right by the child. Okay, and they do make mistakes in this, and I'm not saying that. But you know, the essence of education is to help the kids. Okay, it's like doctors.
Right.
They want to help their patients, but occasionally there's malpractice. Okay, not every doctor, but a lot of doctors. And 99% of doctors, 99% of educators, school districts don't want this to happen. Okay, they really are, most of them, on the kid's side. Which brings me to the question, a lot of this, Howie, and we're going to get into your 7 suggestions that will help the school districts, okay, and the staff avoid all this. Okay, how much when this happens, there's usually probably a financial compensation to the winner. Let's call that person the winner. All right, and are school districts covered insurance-wise with all this, or how do they pay that? Where's that money coming from, or where's that coming from? Yeah, that's a good way to say it. Is it mostly insurance?
You know, yeah. In the big awards, yes, school districts have insurance. Absolutely. They have insurance
for covering special ed, IEP,
for covering special ed, as well as covering other issues in terms of freedom of speech relative to students, in terms of teasing, taunting, bullying, harassment, and so on. But again, you know, from that financial perspective, obviously there are deductibles and so on and so forth. And you know, at the same time, most school systems, the middle to larger ones, they retain a school board lawyer. Okay, but you know, relative to the decisions, more often than not in special education, it's not always about the money. It's more that the parents are awarded or the student is awarded compensatory services. Okay, when you get into the financial use. Well, compensatory services is basically we're going to give you additional services over and above what you're getting right now to make up for what you didn't get before. So it might be additional tutoring, and it might be extended year, summer services. It might be
I have to ask this question
services.
then, based on what you said before. You said that some of these people from during the pandemic, 10 years from now, let's say they're 25, 26 years old, they're not in school anymore. Okay? With the compensatory, how could that happen? I would think it would be financial.
Well, that's going to be a real big gray area, because the deal is in special education, if you're in an IEP, you are allowed to receive special ed services up to age 21. And again, sometimes there's a hedge up to 22. But once you have been awarded your high school degree, to some degree, that's a statute of limitation. Okay?
Wow.
You've got to show, after you get the high school degree, you've got to show some egregious offenses by the school district, almost to the point where the high school degree is largely meaningless. But relative to the financial, there usually are two areas that districts get hit on the financial. The first is in terms of if they lose the case, they usually have to pay some or all of the parents' legal fees. So that's one of the big hits. The second big hit is where the parent has felt that the services of the school district are just absolutely, totally inappropriate. They've taken the student out and put the student into a private school, paid the private school out of their pocket, and that sometimes is where you'll get a financial award where the district will have to pay in arrears for the private schooling that the student received relative to the parent's decision to pull them out.
It is a gray area indeed, and it's coming down the pike. It really is. Howie, we labeled this show, or we talked about labeling the show, 7 suggestions to help districts avoid special education hearings. All right, and do you want to go down those 7 suggestions now? Is this a good time to do that? Okay, do that.
Yeah, and in fact, let's do them in a couple of clusters. Here's suggestion 1 and 2 in a cluster. Suggestion 1, and this is for the district. Admit mistakes. Don't focus on being right. And then suggestion 2 is remember that younger students with disabilities and their parents may be in your district for the next 10 years or more. And the point in all of this is it's about relationships. Certainly it's about quality and effective services and interventions and related services like counseling and occupational therapy, speech therapy. But it's about the relationship. And so, if the school district, if you made a mistake, admit it, okay? Don't get hunkered in and focus on being right. The probability is that if you go through the litigation and you lose as a school district, you're going to have to provide the compensatory services. And I understand you don't want to set a precedent, and I understand that sometimes your services and staff are a little bit thin, but if you made them, if you blew it, then don't focus on being right. Just, provide the compensatory services, negotiate it out, do it in a fair and upright way. But remember that if you soil that relationship early on, okay, if you've got a younger student with a disability and the relationship goes sour, you're dealing with that parent and that student maybe for the next 10 or 11 years. And there's a residual effect. What happens is, as kids grow through the system, teachers change, administrators change, but parents remember the relationship. Right. And so what happens is the student may go from elementary to middle school, and all of a sudden the middle school staff are kind of getting this edge from the parent. They don't understand the edge. The edge originated with the litigation or the disagreements in elementary school, and that just, again, pollutes the long-term relationships. And sometimes what's happening is the staff, as you move into middle and high school, they don't understand where it's coming from. All they see is a parent who basically, quote, is in my face and is
is in their way of thinking over demanding. Yeah,
right, and they don't know the history. So
and there's another challenge with that. I just want to go back to the other side. Is that I actually know people here in the district that I live in that went through this type of thing, and the relationship has been absolutely horrible. And I'm not blaming either side. I'm just saying the relationship was horrible, and the kid was in school, and not that everybody was against her, but that was the perception from the parents. Okay, because things were argumentative the whole time. And you do have to remember that. Kids, a younger kid, you're right.
The kids feel that. The younger kids don't understand it. It's like a divorce, Larry, okay? I mean, sometimes the younger kids, they don't understand the divorce, but they certainly see and feel the acrimony, and that impacts them.
It sure does. Just good advice. Okay, what's number 3, Howie, of your 7?
All right.
That's kind
so
of
let's cluster
1 and 2.
3 and 4. All right, so suggestion 3. Make sure that, and this is from the school district's perspective, make sure that all communications and discussions are clear. And then suggestion 4 is know that the parents know what they know, not what you know. All right, so let me give you an example.
Yeah.
Like, again, we're into legalese. But if we're ramping into due process or litigation, we've got to be mindful of the legalese. All right.
Yeah.
So in the Special Education Law, 2004 IDEA, the Individual Disabilities for Education Act, it says that students with disabilities need to be provided an appropriate education. Okay, they need to receive appropriate educational services. Now, here's the point. From a parent's perspective, what they're saying is, all right, I know what appropriate services are, and school district, you're not giving them to me. But what the legalese is, and there's all sorts of case law, that appropriate is basically your basic level of services that are needed to meet the needs of the student. So we're talking about a Chevy here. We're not talking about a Cadillac, and we're certainly not talking about, a Lamborghini, okay? So school districts by law have to provide the Chevy level of services to a student with disabilities. But again, the communication isn't clear. And so parents are now sitting there saying, all right, I know what appropriate is. It's not in the IEP. This is what I want, and I'm going to litigate, okay? And then the second part of it is parents only know what they know, not what they don't know. So sometimes what happens is a school system may recommend an intervention. And again, the case law is pretty clear. The school system has the right to decide what services supports interventions, what intervention processes or intervention tools or instruments or strategies. The school district gets to make that decision on their own, okay? And again, it's got to be compliant with the IEP, but nonetheless, the experts are the experts. But a parent may go in and say, look, I want this intervention. Okay, and the school system saying, no, we're not going to give it. We're going to give you this intervention. And again, then you get sometimes the parents don't know what the school district's intervention is. It may actually have the same characteristics of the one that they want, but now they're starting to dig in. I want what I want.
Yeah. It's stuff like that. How I got to ask you this, and I wrote this down as you were talking. We're talking about litigation, but what is this a court situation? How much of this actually goes to court? Is a lot of it just around the table with a couple of lawyers and maybe a witness, and it's decided by a negotiating board? What's it look like in reality?
Most of them, when we get to this formal level of, let's just say, debate, it's one of two things, okay? The first, and some states require this, okay? If there is an impasse between the parents and the school district, some states have required and say you've got to go to mediation, okay? So mediation basically is, the parents, officials from the school district or whomever on different sides of the table, potentially represented by their lawyers. The parents sometimes are represented by advocates. So most of the disagreements in a formal sense will go to mediation. And honestly, I don't know the percentage. It varies probably state to state that actually get resolved through mediation. Okay. The next level up is a due process hearing. And a due process hearing, usually it's run by the State Department of Education in the sense that they identify and train what are called hearing officers. And, it is like a court situation, okay, because, there is testimony, there is discovery in terms of, all of the records are open records that we're going to talk about in the due process hearing. There is, there are witnesses, there is testimony and rebuttal. So it basically is set up, in a sense, it is a court hearing.
Is it public?
And sometimes it's
is
actually
it usually public?
No. This is, I don't know any all the different ones, I've probably done about 40 to 50 of these. They've always been private. They're in a room. But
I would assume
again,
so. I was assuming that.
Yeah. It's a formal hearing, and in fact, you can go onto the website of virtually any Department of Education, State Department of Education, and they have to post the decisions. Now, again, names and so on are usually redacted,
of course.
But
that's why I was asking
you can look at the you can look at the history of due process hearings in Maine for the last 12, 15 years, and see what kind of cases are being tried, if you will, again, and what who won.
Well, it's really fascinating. I want to get through these 7 suggestions. We're up to number 4. Let's go to 5 or 6 or whatever you want to do.
All right, so let's do 5 and 6. All right.
Okay.
School districts need to understand, and I'm going to use this loosely, but that parents sometimes go through the stages of grief when they realize that they have a student who is a disabled student or a disabled child or adolescent. Okay? And so sometimes parents are walking into these disagreements, even early on, with a level of emotionality. And again, I'm not being disrespectful or disparaging to the parents, but parents, they're afraid, they're anxious, they're angry, they're in denial, and sometimes they're depressed, and they go through these stages. So that's suggestion 5, is that school districts, administrators, special ed teachers, general ed teachers need to understand that sometimes the behavior and the interactions and the arguments of the parents are to some degree coming from an emotional place as well as from, if you will, a factual place. The 6th suggestion is keep it professional, not personal. And
that's
again,
hard.
It's
hard.
Well, it is hard.
It is hard.
And I'll go kind of 2 directions with this one. One is that sometimes, again, as this gets into due process and into litigation, the school board lawyers are the ones taking the lead. They're lawyers, and I don't want to stereotype them, and again, I don't want to be disparaging to them, but again, they're coming from a different set of standards, a different set of rules and expectations, and sometimes, let's be honest, sometimes lawyers don't always demonstrate the best social skills. You've got lawyers just like anyone else. They're bullies. But sometimes what happens as they're preparing the case for the people who are testifying, meaning the administrators, the teachers, and so on, the teachers and the administrators sometimes model the approach of the lawyer, and they think that, in testimony it's okay to kind of throw a couple of digs, launch a couple of grenades into the discussion. Okay. Now, the other side of it is that sometimes, again, parents from their emotionality, they get upset and they lose their heads a little bit. And so sometimes they do get personal, and they're not as, quote, professional as they might be. And sometimes in the face of that, again, then the teachers and the administrators say, well, look, you know, tit for tat, if they're going to be like that, I'm going to be like that. And
yeah, exactly. Can't do that.
We got to avoid that.
Yeah. Boy, do you have to avoid that. That's not, you're not kidding, for a multitude of reasons. What's number 7?
Number 7 is don't mediate if you don't intend to moderate.
What does
that mean? This goes back to the mediation. Because, again, sometimes what happens is, you know, the school district, quite honestly, or the school board lawyers, they're just kind of playing it out, and they're saying, all right, look, we'll go to mediation. And sometimes they know that there is no way that the school is going to give in to anything that the parents want. And so my point is, you know, and again, I know sometimes your state required to do it, but don't get into the whole mediation process. And if you can, you know, and if it's you know, an elective thing in your state, don't go into mediation when, as a school district, you have no intent to moderate, to negotiate, to try to resolve the situation, because the outcome of that is that the parents are going to be even more angry, because remember, they're paying right now out of pocket for lawyers, okay, or advocates.
Yeah, true.
So if you go into the mediation and basically the school district stonewalls you, the parents walk out, and sometimes they're even more angry than they were before. They're more disappointed than they were before, and they're going to redouble their efforts in saying, all right, we're going to litigation, and we're going to beat those fill in the blank.
Exactly, yeah. I don't have to fill in the blank. I think everybody can kind of do that themselves. I don't have to fill it in for them. You know, it's really just something out there. And I got to say something. Do the mediators take into consideration? And these are tough. Okay, all the pandemic money's running out, et cetera, et cetera. You know, they have to hire more teachers, et cetera. And Howie, you know as well as I do that the federal and state mandates that come down to special education, they tell them what to do. It adds all this stuff, but the money isn't there to actually do it. Okay, so while the mandate is there, they just can't do it. There's not enough staff, not enough time, not enough money, whatever the case may be. In this day and age, knowing that and going into, I'll call it mediation, litigation, whatever the hell you want to call it, just talking about, parents certainly don't understand that. Okay, and they want their kid, and I certainly understand this, to be taken care of according to the law. But the law is putting a lot of pressure on the special ed people. Okay, I'll just use that as the example in the school district. Okay, that they just can't afford, just can't do. There's not, as you well know, there's not enough school psychologists. There's not enough special ed teachers. Go right down the list. How is that affecting the way these things are adjudicated right now, if at all? I mean,
all right.
Does anybody taking that one into consideration?
Yes and no, but quite honestly, mostly no. All right, so let me go outside in. All right, so outside, litigation. If you're in litigation, remember, you're in the court of law. You've left the kingdom of education behind, meaning that whether it's a hearing officer or an administrative judge. I was just on a case this summer on the East Coast. It was a court of law. It was an administrative law judge. Okay, so if it's a due process hearing officer or a judge, they're basing the decision not on resources. They're basing it on law. Okay, so it's much more black and white when you get up to the litigation point. For mediation, and just so you know, I mean, I'm actually a certified mediator. I don't do it, okay? But I went through the Florida Supreme Court training on mediation, okay? And a mediator is different than a hearing officer because the mediator is not there to interpret law. They're not there to make judicial, if you will, regulatory decisions. They're there to try to find a way past an impasse between the two parties.
Yeah.
Now, again, it's nice when the mediator knows about special ed law, because they can counsel the two and say, well, you know, in my experience, the law really doesn't say that, but, you know, I'm not here to make pronouncements on law. I'm trying to help you guys to resolve some issues. So in mediation, resources may come more into the picture, but only if the parent is willing to allow that into the picture. The bottom line is this. It's called an IEP for a reason. It's an individualized education plan, okay? The law says, in most cases, the law says that if a parent signs to have their child evaluated for eligibility, you've got whatever it is, 45 days, you've got 60 days to do it. And you know, on a legal level, and it's not that the parents are saying it this way, but on a legal level, you know, if you don't have enough school psychologists to meet the regulations and you don't give me a report until 5 months down the road, okay, then by law, I have the right to contest that.
Of course, they do.
So again, you know, the resources are embedded in it. But once you're more formally into the legal part of it, the resources are not as critical in terms of the decisions.
And Howie, let me ask you this. These days, okay, just I'd say generically, anecdotally, which way are the courts, I'll call the whole thing the courts, or the mediators, or however you want to say that, which way are they leaning these days? Are they tend to be leaning more to the parent, or are they leaning more to the school districts? My bet is the school districts, but I may be totally wrong.
Right. Yeah. No, it's pretty universal. It's not absolute, because, you know, it's going to vary some by state to state.
Of course.
But in general, the school districts largely win. Okay. I mean, I'll ballpark it. Maybe 80% to 20%, and again, I don't want people to quote and footnote me, okay? But I mean, we're not talking about, we're not talking about 55 to 45%. I mean, in most cases,
substantial majority. Yeah,
it's pretty substantial majority. The school districts win. But the point is,
and again, I'm just going to say this: the school. I'll say this till the end. The school districts want to do the best for kids. Sometimes they just can't, or they make an error. I don't know. I can't. Sure. I would find it hard that very few would do anything intentionally to harm a kid. That I do from everybody I know out there.
Right.
You know,
but I don't want that. I don't want that statistic to empower school districts, because understand, you may win the short term, but you may lose the long term relationship. But there's another factor here, Larry.
It's called a pirate victory.
It takes hours and hours and hours to prepare for, to practice for, to litigate a case. You have to drag teachers, related service people, administrators into court. Their anxiety is sky high. Yeah. There's a human toll, even on the school district, to litigate. Yeah. And so just because the districts usually win, that should not be a free pass for school districts to say, well, okay, we'll go to litigation. We're probably going to win. So
yeah, because like I said before, it's a pirate victory. You remember that from history class? Yeah. Yep. You know, it's that kind of a thing. And, school districts have to be aware, okay? And the parents have to be aware too. Okay, and the simplest answer is work it out. And the other simple answer, if I may be so bold, school districts, Howie's at projectachieve.info. And he, as you just heard, he knows his stuff. And working with your school, if he can work with your school district, you'll be able to avoid a lot of this. Okay, or have great help if it happens. There you go, Howie. There's a plug for you. Okay, projectachieve.info.
Right. Well,
okay, you know, it's good stuff. I got to tell you. Yeah, go ahead.
Yeah. And again, I mean, I certainly work with school districts that are in a pre-litigation phase. But, you know, I do two things. One is I'm a straight shooter. And, if a district or a parent comes to me and they say, all right, here's the case, and I get the basic documentation, I'm going to tell them. And if the district's sitting there and they really don't have a leg to stand on, it's my responsibility to tell them that.
Yeah, exactly.
But what I can do second to help is I can say, look, this is what, from my professional experience, from my 40 years of working across the country, this is what you need to do. Here's the multi-tiered system that you need. Here's the social-emotional learning system that you need. Here are the interventions for this behaviorally challenging student. So I'm not going to just leave the school district hanging and say, yeah, you don't have a case. I'm going to say, look, let me help you to close the gaps so that everyone hopefully can win. So here's the summary, Larry, okay?
Sure.
Right. What I'm trying to do, and I hate that this is more medical, but I couldn't come up with a better acronym. I'm trying to help the school districts to cure themselves relative to avoiding special education hearings and acrimony. All right, so the acronym is CURE. Okay.
Yep.
You've got to have communication. You've got to have understanding. You've got to have relationships and relationship building, and you've got to have empathy. So you've got to communicate. You've got to understand the law and what you can do and what you should do. You've got to maintain those relationships with the parents, and you've got to do it. The best path to do that is through empathy. And, what Covey used to say, he said, seek first to understand, then to be understood. So sometimes as we get into some of the grumblings relative to, the school district and the parents, I'm really encouraging the school district. Seek first to understand. Try to understand the parent. Understand where they're coming from. Understand their child before you start pressing them to understand what you as a school district can and can't do or maybe won't do.
Can I say that they've got the fever, but Howie has the cure?
There you go. I love it.
That wasn't bad. You got the fever, but I got the cure. Howie, this is good. Yeah, it's good stuff. You can take it as a trademark, buddy. Okay? This is good stuff, Howie. We got to go in just a minute or so, but I just want to thank you, as always, for being here. I love having you on, as you know. Okay? So thank you for everything you do for us and for school districts. Appreciate it.
Hey, it's my pleasure.
Mine as well. Have a good one. Have a good weekend, Howie.
All right, you too. Take care.
Thanks, buddy. Bye-bye. And that, ladies and gentlemen, was Howie Knopf. Howie, Dr. Knopf, okay, is over at projectachieve.info, and he knows his stuff. Okay, he knows his stuff. That's all I'm going to leave it at. We're going to archive the show over at ace-ed.org. I'm Larry Jacobs. Thank you for listening, and have a serious and thoughtful Veterans Day weekend.